current job in the summer of 2017, did anyone affiliated with the Trump administration, Trump transition team, Trump campaign, or Trump organization ask you for your opinion on whether the Trump organization was in violation of the lease for the old post office?
I had no communication with anyone from the Trump companies while I was being considered for this position. No.
Have you ever had any communication with any current or former GSA employees about how the White House or President Trump would respond if he were forced to divest from his business interests?
Well, I worked for this subcommittee as the majority staff director, and we certainly received briefings from GSA on this very question.
Thank you. Ms. Okoa, in January of this year, your office issued a report that's been described that outlined the failures of the GSA to address the issues with the lease, including those that pertain to the emoluments clause. Is that correct? And on March 29th of 2019, GSA delivered a corrective action plan to you in response to the recommendations of how they should remedy the issues with the hotel lease. Is that correct? And did you find that GSA's plan to remedy the situation was sufficient?
We have not agreed with the agency's corrective action plan to date.
And in your judgment, did GSA adequately clarify the section of the old post office lease that prohibits elected officials from being a party or beneficiary of a federal lease?
It's my understanding that GSA has not undertaken the analysis we requested.
Did GSA bother to do the legal review of the emoluments clauses that they failed to do when Donald Trump took office and that you recommended?
I have no information that they've done that.
So GSA went back, and is it correct they submitted another plan to you in August 26th of 2019? Is that correct?
I think that's the right date.
And did your office find that their plan to remedy the situation on that day was significantly different from the one that they'd submitted back in March?
No, it is not.
I've got the two documents here. The first is the GSA's corrective action plan dated March 29th, and the second is Inspector General's communication with the GSA on September 6, 2019. I'd ask for unanimous consent that they be entered into the record. Without objection, so ordered. Section 3719 of the lease states that no member or delegate to Congress or elected official of the government of the U.S. shall be admitted to any share or part of this lease or to any benefit that may arise therefrom. Ms. Okoa, your agency said that the GSA needed to clarify this language. Is it true that GSA attempted to clarify this language by claiming that it should only apply to members of Congress and not the President of the United States?
The corrective action plan proposes to drop the language from Section 3719 that prohibits both state and local elected officials and the president and vice president from benefiting from the lease.
So their way of dealing with the problem of the president coming under the emoluments clause was to drop the president from the lease and just say that in the future this would apply only to members of Congress, but not the president and the vice president. Is that correct?
Or state and local elected officials.
For both clauses then, yeah.
That's my understanding of their corrective action plan as to Section 3719.
I find that astounding. And on top of that, is it correct that to date GSA has still, in your judgment, failed to uphold its constitutional obligation by conducting the legal review of the emoluments clauses?
Yes, I'm not aware of their effort to look into the emoluments clause in connection with how it affects interpretation of Section 3719.
Mr. Matthews, I'm sure we're in agreement that the President of the United States is an elected official of the government. Given that the agency's independent IG has just said that you failed to uphold your duties under the U.S. Constitution, can you commit that the GSA will conduct a legal review of the emoluments clause as they pertain to the Trump D.C. hotel?
I guess first I'd like to just respond to our corrective action plan. So with respect to the interested parties provision, GSA agreed to no longer use the language contained in Section 37.9 in future out leases, not in the current lease, in future out leases. So I just wanted to correct that.
So in future leases, only Congress is prohibited, but not the President and the Vice President, in case there are future leases. We got that.
Correct.
Now, will you conduct that study of the legal implications or legal review of the emoluments clause?
So on that question, what we propose to do in future out leases is to remove the ambiguity from that interested parties clause by striking it and referencing the statutory basis for that clause. So there's a direct reference to that statutory reference. That's what we're proposing to
That
do.
statutory reference does not supersede the Constitution. So it seems to me that the IG's investigation revealed that y'all just completely ignored the serious legal and ethical questions here. And your response to their recommendations was not to follow the recommendations, but to strike the president and the vice president and say, oh, that just applies to Congress. Thank you, and my time is up. Mr.